for this meeting. We are in the home stretch. We have today's meeting, and then we have another one on Wednesday to consider a number of other proposals. And before we do that, I wanted to present a proposal on peaceful demonstrations. This is something that's really come to the fore in the wake of the protests and the killing of Mr. George Floyd. And then it was underscored again 2 weeks ago in Alamance County. And we are going to be sending around for your review basically a recommendation that all law enforcement agencies have a policy on how to handle peaceful demonstrations and mass protests, and then a model policy of best practices. And this was formed off of national literature as well as Charlotte-Mecklenburg, which just reviewed their policies. And so you all will be seeing that, and please take a look at it and have your voices heard on the straw poll, and we will consider that next week. The other co-chair proposal we wanted you all to consider, which Justice Earls previewed for us last week, has to do with the future work of the Task Force for Racial Equity and Criminal Justice. And it talks about how we intend to operate over the next 2 years on a going forward basis, and how we're going to be structured, that we want to meet quarterly. We'll break our work up into 4 different groups, meeting, I think, monthly. And if we need to meet more often or less often, we can modify as needed. But the idea is not to put as much demand on your times as we have these past 6 months, which has been an incredible imposition, but an imposition for good. And I thank you all for your willingness to suffer that imposition. The other thing we want to do is have some kind of permanent structure beyond the life of this task force, which would be to create a commission on racial equity and criminal justice system. And there, in that proposal, which you all have seen, it lays out how that permanent commission would be structured. And thank you, team, for putting up this slide that reminds us of what this permanent commission would do. The important thing is just for us to, on a going forward basis, keep this issue at the fore, that when criminal justice policies are being considered, we do a racial impact statement, that we keep data, we continue to build and improve the data sources to improve the quality of our decision making, and then have metrics and monitor the effects of the changes that we've recommended and implemented. And so this is the proposal. And at this point, I think everyone has seen it, and there was widespread support for it, but wanted to put it open for discussion for the full group to see if folks had any questions or ideas, thoughts, or improvements. Okay. Y'all just want to go ahead and take a vote on that one? Why don't we put the poll up and we'll see where we go. Maybe this will be the most efficient meeting we've ever had. Okay. Should be on everyone's screen and they can cast their poll.
All right, we have 17 folks who have voted, who I believe that's the count. If anybody needs any more time, I've not counted you. Please raise your hand. Okay, an 18th person. Excellent. I'm going to end the polling and share the results.
Great. That one was unanimous. to establish a permanent commission after our lives are over as an institution. Okay, we will now proceed to working group 4. Henderson.
Thank you, Attorney General Stein, and good morning. We're excited to share with the task force some of the hard work that we've been doing over the last several weeks, and most especially in this last week. During our last working group meeting, we had a presentation from Professor Jim Coleman at Duke. And Professor Coleman's been doing good work with the ABA, with Wilmer Cutler Pickering, one of the most preeminent law firms in the country out of DC. And then for the last couple of decades at Duke University, he is in all senses a national treasure. And much of his work has revolved around the issues of wrongful convictions and the death penalty. And Professor Coleman took the opportunity during that session to go through the recommendations that have been bubbling up at Working Group 4, and noting that much of the supporting documents for the ideas and the recommendations in Working Group 4 about the death penalty have been placed in the SharePoint. So whether it's the racist roots study by CDPL, references to the memorial and the monument and the museum and the memorial in Montgomery, or the number of studies regarding the cost of the death penalty, issues of racial disparities with exonerations. There's an enormous library of materials that have been collected over the 40 years. And we've tried to curate those materials and make them available to the working group. But what Professor Coleman was able to do was share with us his experiences with some of the gaps, the many gaps in our criminal justice system, and how they come to a head in the administration of the death penalty. What we did in some fashion is go through in workman-like fashion the recommendations that the working group had come up with to get Professor Coleman's view. And I think what I'd like to do is share some of that. We've got a few minutes this morning to share some of those discussions and to discuss how we got there. I thought, however, one of the best questions that was posed to Professor Coleman came from our own Mike Hawkins. At one point, Mike asked the professor, well, what if you don't see the death penalty as sort of inherently morally wrong? You know, what if you're not schooled to all the issues of history with the death penalty? How would you argue, and how would you explain? How would you describe the reason why the death penalty should no longer be sustained in North Carolina? And I think that question was the appropriate challenge, I thought, for the presentation by Professor Coleman. And I think sort of working through the answer to that question answers some of the recommendations that were made. So going through the specific recommendations, the first was recommending the establishment and funding of a conviction integrity unit housed at the Office of Indigent Defense Services. Coleman has been operating for a couple of decades, an innocence project, a wrongful convictions project at Duke Law School, taking advantage of volunteer law students, really bright kids, really bright soon-to-be lawyers. But that really does not match the need. And Professor Coleman described how good and encouraging it is to work with students. But when you've got 34,000 prisoners, and when you've got 140 folks sentenced and condemned to death, to rely on a system that is student-led is not what a state like North Carolina should do. And that we should take on this issue, fund the appropriate resources to investigate prisoners who have come through a system with as many flaws and gaps as our justice system has. I thought one of the compelling presentations that Professor Coleman noted was that of Ken Rose, his description of the death sentences that occurred before 2001, at a point where prosecutors did not have the discretion not to choose a death sentence in prosecutions for first-degree murder. This was much like the pre-Furman decisions, where North Carolina was one of the few states that mandated the death penalty for convictions. Well, after the return of the death penalty, we sort of held on to that mandatory nature through judicial interpretation. And that didn't change until 2001. And so there's a body of convictions of condemned persons who are on the roll, largely because the prosecutors didn't have the option to seek first-degree murder, even though the defendant may have been impaired with serious mental illness, intellectual disabilities, youth and immaturity, all of the many reasons why a person would be something other than the worst of the worst. And so that creates a very clear dividing line where you can look at a class of prisoners on the row and say, these people wouldn't have been placed on the row if the prosecutions had occurred after 2001. Their presence on the row is no longer compatible with the general principles that have been operated even in the criminal justice system in the state since 2001. And one of the recommendations is this class of condemned prisoners would be appropriate for the governor to use his resources, in this case, his resources, to investigate the merits of executive clemency for that group of inmates. A second principal recommendation, and that I would discuss here, is the acknowledgement that we in North Carolina have not executed a prisoner since 2006. So as a matter of fact, there has been a moratorium on executions. And our suggestion is let's move that away from a de facto moratorium to a formal announced moratorium, much like 4 other states in the country who have announced moratoriums, and connect that moratorium with an intentional review of the statute of the state's administration of the death penalty, and breaking out the issues that should be reviewed by a study commission. So that the recommendation is to announce a moratorium pending the return of a study commission's report about the state's administration of the penalty. And in announcing such a study commission, we would identify some of the questions that would be answers to Mike's question. These would be the points of public education that would be most productive. And leading those series of questions is, what about this issue of racial disparities? How does it impact the death penalty administration? Whether it's the race of the defendant, the race of the crime victim, whether it's the race of those who are called upon to participate in the adjudication, jurors. What do we know about those racial disparities? How does the Michigan State University of 10 years ago, which has been recently updated, how does that inform those questions? What about this question that the death penalty reserved for the worst of the worst should not be imposed on young, immature minds? The US Supreme Court recently drew the line at the age 18. Science tells us that the brain continues to develop until age 25. And for males, it might be 26. Well, should we, as a state, draw a line that categorically protects those who are youthful? Mary?
Yeah, thanks. I think my understanding was we were going to get into this at the next task force meeting, and I don't want to like cut you short or anything, but we have a ton of stuff we need to get through for the recommendations on the sentence redress and the prison discipline. Just trying to be, you know.
I think I see that as a very, very friendly admonition and reminder. Thank you. I did want to sort of tease up these issues for the larger task force to both look at the SharePoint and to engage with other members of Working Group 4 if there are questions that these issues prompt. Now, with that sort of hook and umbrella, let's move to the number of issues that we've got teed up today for the task force consideration. They cut across several issues, and we've had tremendous input and feedback from stakeholders, most especially from the Department of Public Safety, and both Mercedes and Mary and I have been fully engaged with them. Mary or Mercedes, do you want to sort of go through in sort of workman-like fashion the issues that we think that we would like to line up for the task force today, and sort of announce some of the feedback we've gotten and some of the modifications that have been made?
Yeah, I think, so yeah, we have 3 groups of recommendations related to collateral consequences, redressing lengthy sentences, and I don't want to call it prison discipline because the recommendation expanded into lots of other prison issues, right? Making prison a safer and more humane and more productive place. I think if it's okay with Mercedes, I'll let her kind of walk through the collateral consequences because she's got a lot more expertise than I do, and then the rest of us can chime in as necessary either during that portion, or I'll have more to say about the other 2 topics, I promise you.
Right, so the next slide here, collateral consequences, broke down into 4 separate recommendations, primarily the first being in relation to voter disenfranchisement, and that recommendation being extending the voting rights to those on probation, parole, and post-release supervision for a felony conviction. Currently, those individuals are prohibited from voting. The second recommendation is North Carolina currently has a modified ban on SNAP benefits for individuals with certain drug charges, felony drug charges. This recommendation is encouraging North Carolina to opt entirely out of that federal ban, which would result in eliminating a 6-month disqualification period and other requirements that are necessary for individuals to be eligible for SNAP benefits immediately upon release. Third recommendation is allowing DMV officers to waive the hearing license restoration fees and other service fees that are related to failures to appear and failures to pay. We understand from the division that is something that they would, something in the statute that they would appreciate to be able to have explicitly in there. And the fourth being reforming the certificate of relief petition process so that individuals with multiple convictions across multiple counties only have to go into one county of their most serious conviction to address the collateral consequence. We had some feedback on this recommendation. Ultimately, this type of relief doesn't affect the underlying conviction or the sentence. It really just is addressing the collateral consequences that are a result of those convictions and sentencing. And so that's currently as written. And those are the recommendations related to collateral consequences, if we'd like to discuss those now.
Representative Marshall.
Yeah, the one I'm wondering to opt out of the federal ban on the SNAP benefits? I mean, isn't that a federal requirement? Can we?
So
how would we?
It can be done by statute. Many other states have done it by statute, and there's materials in there in the SharePoint about how other states have ultimately written the statutes. I believe North Carolina is maybe one of 20 states that has this type of modified ban, which allows individuals with felony convictions to be eligible for SNAP benefits. Only 6 months, they have to wait a 6-month period, and then they have to do some drug treatment and rehabilitation programming. And so ultimately, opting out of the ban completely would eliminate those requirements, would allow people to be immediately eligible.
So refine our statutes on that. Okay.
Yes.
Great, thank you.
It is a statutory change, yes. Any other questions? I suppose, I'm not sure if we want to vote on these now or if we move on to the rest of the discussions on the other.
Yeah, this is Colin Pittman. I just got a quick question. Was there any discussion surrounding expungement clinics being more accessible or promoting them more around the state? Was there any discussion surrounding that?
We discussed a handful of recommendations related to reentry and reentry resources. We didn't discuss expunction specifically. At the next a future meeting, we'll see a recommendation related to supporting the recommendations that are being put forth by the SRCC, the Statewide Reentry Collaborative Council. I know that organization typically has a lot of work and is working heavily on expunction work. So you should see those recommendations in that, probably through that link.
Why don't we go ahead and go to the other substantive topics, and then we'll vote on all of them at the same time. I see Commissioner Smith.
Yes, yeah, yes.
I think he was waving at somebody.
Yeah, he's like, so I guess the next set of recommendations would be redressing sentences. These broke down into 3 different groups of recommendations. The first being reduction of racial disparate sentences through the review of those who are currently incarcerated. Then the second recommendation breaks down to increasing DPS's flexibility at reviewing currently incarcerated individuals' release dates. And the third set of recommendations relates to future sentencing. And I will run through very quickly just the kind of the titles of these, and I expect that Mary and Henderson would want to speak up to them in more depth. So the first is reinstating RJA for individuals sentenced to death. The second is creating a clemency initiative that involves using an advisory group of stakeholders. And the third is establishing a Second Look Act. The Second Look Act looks at requires the review of sentences at a 20-year mark before a judge or a panel of judges, using the appointment of counsel if a threshold showing has been made, and would only be provided if certain conditions were met. And so I will open the floor to Mary and Henderson to speak on those, and anybody else has questions.
Thanks, Mercedes. Yeah, the clemency initiative, I think that goes hand in hand with our earlier recommendation that the task force adopted of expanding the resources available to the governor so that he can exercise this historic constitutional power he can in appropriate cases. This just gives him more information and will hopefully bring more people to his attention so he can exercise that power responsibly, or so she can with future governors. The Second Look Act, so the intent here is that we had hoped for some sort of judicial review. In my prior life at Prisoner Legal Services, we saw so many cases of young people, young men mostly, who did stupid things when they were 19, 20, 22, 23 years old. And then they had their sentences boxcarred and they end up serving decades. And I think those lengthy sentences, that there are racial disparities, and this just gives the courts an opportunity to revisit those sentences in appropriate cases with appropriate safeguards. On the reinstituting the Racial Justice Act, I think Henderson has far more expertise on that than I do. But certainly after reading the most recent round of Supreme Court opinions, our state Supreme Court opinions, this seems like a prudent and important step.
And the reinstatement of the RJA would actually be for that gap of prisoners who have been sentenced after the repeal of the RJA, and would not now have the opportunity to file and challenge their conviction as unduly affected by race. So the relative number of people impacted by that is relatively small, but it's also future oriented for any future folks who are convicted and sentenced to death. Yeah, I think there's one comment that has run through some of the feedback that we've gotten on the Second Look Act and other provisions that attempt to look back at prior sentences, and that's that there's something of a promise that was made to victim families and harmed parties at the time of the original sentencing, and that prevents any change in that without a break of promise. And that's a position that I view really needs to be reviewed by the professions that serve justice administration, what the nature of sentencing is, and how we're defining justice and the pursuit of justice. Whether or not any particular stakeholder has a bond or a promise with a particular sentence. Having sort of lived through the Willie Horton era and the truth in sentencing, I understand the tensions that are involved in that discussion. But part of what the transformation we're talking about is looking back at sentencing decisions that were made at a point where the values are very, very different than those that we share today.
Okay. All right. The second set of recommendations that fell under redressing sentences was increasing DPS's flexibility on the release date for currently incarcerated individuals. That looked like 3 separate recommendations. One was expanding the access to funding, expanding access and funding for DPS programs related to release programs, such as tools like the extended limits of confinement and any type of sentence crediting program. The second recommendation was eliminating revocation of, and I believe we changed the language here to read CRV for technical violations. And Jasmine might be able to jump in here, but it ultimately is the same idea, just more technical language. And then the third recommendation was creating a task force within DPS to examine the racially disparate outcomes and access to these programs and outcomes associated with their work.
On recommendation number 1, I think that the hope is, or the goal is, that DPS would have the resources it needs to ensure that every person who's incarcerated has the opportunity to either have a job or participate in programming that would allow them to work down to the minimum sentence that they were sentenced to. There aren't enough jobs available in DPS for all the folks who want a job, and there's probably not enough programming or enough different kinds of programming. On the second recommendation, eliminate revocation of post-release supervision for technical violations. When I was at PLS, there were a number of lawyers at my office who did a lot of work on post-release revocation cases before the Parole Commission, and most of the violations they would see stem from homelessness and mental illness and or drug addiction. And particularly right now in the time of the pandemic, there aren't a lot of resources out there to help these folks. And we're kind of setting them up to fail if we let them out and then revoke them and put them back in. the parole officers have a whole toolkit of other less severe sanctions they could impose instead of revoking somebody. They can require drug classes, right? They can do house arrest, ankle bracelets. So there are alternatives.
And Mercedes, I'll just jump in and explain the couple of tweaks to 1 and 2 that were based on DPS feedback. And I understand that Secretary Hooks is now on the line as well. So he may want to participate in the points on that. But on number 1, we changed the language from authority, programs and authority to programs and tools to make clear that extended limits of confinement is a tool that DPS has available to them. And the one of the major points of this recommendation is trying to make is that that this is not just an access issue, but also a funding issue, and that significant funding would be needed for DPS in order to have more access to these programs and to these tools. And then second, yes, in the actual recommendation language, the program, what happens for these technical violations and other violations is called confinement in response to violation, CRV. And so we changed that language from revocation, just for situational awareness.
Although I'd like to say that from experience with clients, a lot of these folks, this doesn't mean they go back to one of the CRV centers necessarily, which has targeted programming. A lot of them are just sent back to regular prisons from our experience. So I don't want to lose sight of the big picture there. Okay.
Good morning, everyone. This is Secretary Hooks. I just wanted to weigh in just on a brief, and I won't try to jump into technical edits really, but this is just like a technical distinction that extending limits of confinement is not actually a release. Those people are still in custody as ordered by the court. It just has a very limiting tool that where I may be able to place individuals into the community, but they have to be under the supervision of a community corrections officer. That's in addition to their regular caseload for post-release or parole. And so it's not a release when they go on extended limits of confinement. It has traditionally been used to allow an individual to maybe get medical treatment out of state or in a hospital, or to attend a funeral of a loved one. But because of the extraordinary circumstances of COVID-19, we have kind of stretched it within legal confines, have stretched that ability to use that tool to place individuals in the community under supervision. And so it may feel like a release to some degree, but they're still in custody because I'm still bound by the judicial orders that place them in custody. We've just expanded where they're in custody at.
Yeah, and this is Angelica, and I'm just more commenting on the other recommendation around the 20-year review. I just want to reiterate a point that I had made at the last meeting about what victims and survivors oftentimes want, which is, one is for that person not to commit the same crime again. 2 is also the acknowledgement that they have committed a wrongdoing. And 3 is that there's rehabilitation somewhere along the line. And granted that no victim is the same, I don't want to blanket that all victims feel the same way, but for the most part in the work that I have been involved for numerous years, that seems to be a pretty reoccurring theme. And in terms of the other recommendation on the 20-year review, it is just a 20-year review, and it is for appropriate crimes to be reviewed. And so I think that as it relates to anything that impacts victims, I just want to make sure that we don't paint all victims with one broad stroke as to what they want and what they don't want. And also, again, as said previously, the encouragement of really incorporating victim voices in some of these processes of the recommendations that impact them directly.
Angelica, is there, sorry, Michael.
Oh, go ahead, Jasmine.
I was just asking, is there not that I want to introduce amendments necessarily, but is there an amendment or suggestion that you're specifically making regarding that? I know when we get to working group 3's victim-related recommendations, there is an explicit role for victims in the development of restorative justice programs. So I was wondering if there was something specific you were proposing there.
Yeah, just that the victim voice be included, and I know that we are been taxed on a time frame, and I don't even know if it would be possible to put together like a subgroup of victims or victim service agencies to offer that feedback around the recommendations that also have an implication as it relates to victims. But it's certainly something that I would encourage for us to think about. If that was even a possibility. Certainly incorporating more of that voice, and again, the whole piece of as we move through these recommendations, just knowing that we can't assume that victims or survivors will go in one direction or in another based on our sole interactions with victims. Just as a whole is what I'm trying to encourage and remind us.
Thank you. I think in terms of the development of the actual language of the second look act, the idea is it would be a judicial process. It would be back in the courts. It would have the involvement of all the actors, the district attorneys, and it would have to, of course, comply with Marcy's law and other laws and procedures that I hope would allow a victim's opinions and voices to be heard. So I would anticipate that as I envisioned the statute as it were drafted and developed, that it would incorporate that. So.
But Mary, there's nothing explicit in this proposal that references victim notification.
It's certainly not a fully baked statutory proposal, and certainly we could, if Angelica we're proposing an amendment to ensure that any statute that be developed incorporated voice for the victims. I'm not good at drafting on the fly, but
I would say that during the working group, we did identify harm parties, individuals, family, and community as among the stakeholders that would have a seat at the table. You know, when the issues come back for the court's consideration, along with employment, institutional history, and those other matters, the views of harmed parties was also to be included. So while we haven't drafted the legislative language, I think the working group certainly considered that an important stakeholder.
Thank you. Thank you for the clarification. It really heartens me to hear that has been a part of it, because that is a core piece of what we talk about justice, right? Especially when we talk about restorative justice practices and just in general harms to the community and individuals. So I really appreciate that that was part of the conversation.
Absolutely.
And I'll propose an amendment, I guess. I think I can do that, even though it's our own working group's recommendation, that we include that the whatever legislation is drafted in response to, or a second look act will also respond to the needs of harmed individuals, families, and communities in response to violent crimes to effectuate the goals of public safety, harm reduction, and restorative justice. And I'll try to put that up in the chat before. How does this work? We don't vote until the end now that I've made an amendment.
Correct. We'll put that one to the end, and whatever language you put in the chat box will be incorporated into an amendment.
Okay, I'll work on that.
Thanks,
Mary, I'll grab it once you do so.
Thanks. Okay.
Jim, I see that you unmuted yourself. I didn't know if you wanted to comment.
Yeah, I mean, I've been in the position of being opposed to this, and I've talked to a number of victims, and I've had communication with a number of victims over the last few weeks. And my experience is very different, because most of these cases we're talking about are going to fall into the category of murders, sexual assaults, and rapes. And the victims here in my district, and I've talked to a number family members of homicide victims are very opposed to this. They feel like the court process gave them some degree of closure, not complete closure. Nobody ever gets complete closure in a homicide or a sexual assault. They have to live with it for the rest of their lives, but they're very concerned about reopening those wounds, having to come back into court when they believe, based on the law at the time, that they would not have to do that again. You know, and I'm talking about people, you know, I've got a case here where 2 children were raped and murdered. I've got a case where a young man was executed by his so-called friends. I think there were about 7 that I eventually tried for that homicide, and on and on. And then sexual assault. So in my district, at least, the victims who reached out to me and who I've reached out to, and it's been a number, have all said they don't want to have to revisit this. And they thought, based on the law, that they wouldn't in a courtroom. And I have this come up with motions for appropriate relief are filed. I had a case that occurred in 1985 in which a woman, her son was killed. He was murdered. He was shot in the back because he turned around to look at the person who was robbing him. And a motion for appropriate relief was filed in that case, and it reopened a lot of wounds because we had hearings on that case. And the irony of it was in 1985, I worked at the University of North Carolina at NC Memorial Hospital. I had been the one who called that lady that night to put her on the phone with the surgeon to tell her her son had been murdered, had been killed, had died in the ER. And then I picked up the phone 25 years later and happened to be the one who called her to tell her there was a motion for appropriate relief. A judge had ordered an evidentiary hearing, and I wanted to give her the opportunity to be heard. She said she had lived with that night all of her life. And it was very upsetting to her that the case was being reopened. The motion was denied, as it should have been. But I've dealt with that over and over again as a prosecutor over the years. And I feel like I've got a good feel for the victims here in my district, particularly homicide and sexual assaults. And I do think this re-victimizes them. So I'm opposed to it.
Can I add something as someone that has been doing anti-sexual violence for a while, is that, again, no victim or survivor is the same, but I am going to say is that in my experience, especially as it relates to victims of sexual assault that are women of color or from marginalized communities, that they are less likely to call law enforcement, because especially when the perpetrator is also someone who is a person of color, because the reason we're here is to try to improve the justice system where justice is just. And what I've seen in my experience is that there are a lot more survivors of sexual assault that are women of color, men of color, that are less likely to engage with the criminal justice system because of the disparate impact on people of color. And so for us, which is why I'm so heartened by the fact that this task force was created and that we're all coming to it with this charge of like, how do we have racial justice in the criminal justice system? And just know that from my experience, people of color, women of color, victims of our marginalized community are less likely to engage with the criminal justice system, make a report, call police because of the disparate impact on communities of color.
And I guess I'd like to say first that I respect Jim's position and his experience. I've been at the bar for 39 years from the opposite end of the bar. And so I've had the honor to sit with family members who have been impacted by murder and by serious violent crimes. And this group is not monolithic. I've had many who expressed the point of view that Jim described. I've had so many others who took take a very different point of view. And I think part of the reimagining process that we've got to go through as a community is what it is that we're asking and telling harmed parties, families, and communities about how the justice system works. You know, part of what family members want to see is that they're safe and their community is safe, and that there's progress being made by the person who did this terrible thing. This year, I had the opportunity to talk with a family member whose child was murdered, whose son was murdered by a young man who was 15 years old, 14 years old at the time of murder, and sentenced to life without parole. When that came up for review, clearly, in some sense, it's painful to relive it. But it was also an opportunity for the family member to see the progress of what had happened and to think through whether or not a life without parole sentence is appropriate for a young man of his immaturity at the time of the crime. And there was no opposition to the sentence, the modification of the sentence, which was modified to 20 years. I think that's representative of a significant part of the community of folks and families who have been harmed by crime. And I think part of what the second look at is offer an opportunity for that view to be expressed in a system where for so long that view had not been given air.
You know,
thanks, folks. Oh, go ahead, Mayor.
I just want to say there are some really hard and difficult cases out there. I've seen so many cases where people are serving decades for crimes that did not involve homicide or sex offenses that were committed when the person was at a very young age, and those folks need some relief. I'm sorry, Michael. I'm done.
Thank you. And I think some of this is going to be referenced when work group 3 discusses some of their looking at victims and restorative justice and whatnot. So maybe the conversation can come back to that later on. We have about a half an hour left for work group 4.
Hey, I just wanted to say real quickly, if we removed, murder cases and sexual assaults from this consideration, I would agree with Mary completely. I think it would be very different then, but those two category of cases are what concern me so much, and the victims and family of victims and survivors in those cases.
Thank you, Jay.
I think we can probably go to the next slide. And this is the addressing future sentences. So the third part of our redressing sentences recommendations has 4 parts. One being, for all those that are sentenced in the future, we would now have a 20-year review, similar to the second looked at, which is applicable to those that have been sentenced in the past. The second is creating a sentencing commission to review some of these racial disparities, specifically in prior record level calculations, sentence lengths, habitual felon status, drug offenses, including a report there. We'd be expanding, the third one is expanding advanced supervised release, which is done at sentencing, which allowing individuals that are incarcerated to work towards reducing their minimum sentence by providing an education campaign on how individuals can do that, and for attorneys as well. And the fourth one is eliminating the future use of violent habitual felony status. And we can open those up for discussion.
So I just wanted to jump in. The first recommendation there, I guess, would mirror whatever language the second look act looked like, right? It would just apply in the future as opposed to retroactively. I would like to propose an amendment to recommendation number 2, that this analysis include the use of the felony murder rule as a basis for first-degree murder. We tried to get some data on whether the felony murder rule was used disproportionately against people of color, but the data isn't readily available. I think it's something we need to look at. As the law stands now, you know, if felony murder is first-degree murder, the sentence is life without parole or can be death. And you don't necessarily, it's a murder that happens during the course of the felony, and you don't have to be the person who pulls the trigger. There are some really unjust felony murder cases out there. So I'd like to make propose an amendment that our bullet point number 2 be included to study the use of the felony murder rule. On the number 4 recommendation, eliminate the future use of violent habitual felony status. Mercedes, I'm not sure if we have the statistics readily at hand to throw up on the screen there, but this is a status offense that carries a life without parole sentence. It's extraordinarily rarely used. I can't remember the numbers, but I think there are fewer than 80 people in the Department of Corrections serving time for this offense. It's rarely used, it's arbitrarily used. We don't have the data about how often it could be used and isn't. But I know when I was at Prisoner Legal Services, we would come across one of these cases every once in a while, and I would just really scratch my head because I'd seen a lot of other folks with way worse records who weren't indicted as violent habitual felons. And I'm thinking in particular of a man named Mr. McDougald from Harnett County who was convicted of violent habitual felon for a second-degree kidnapping. And one of the priors that was used to support that indictment was a Class E felony from when he was 16 years old. So we do have data that shows this is disproportionately used against African-American men, I think 80% of the time. It's used more frequently in predominantly whiter counties. This isn't really a soft on crime recommendation because if you're eligible for this, right, you have at least 2 prior Class E felonies, you're at least a level 3 prior record level. The district attorney has other enhancements, the regular habitual felon sentence. Somebody's looking at 20, 30 or more years in prison. So I would propose the elimination of the violent habitual felon law.
I've thrown those numbers in there. It is 81.6 black, 14.2 white, with 49 individuals.
It's arbitrary, it's rare, it's like getting struck by lightning, and it just needs to go away because it's misused. It's a misused status offense.
It's only been used maybe 53, 57 times in the last 19 years.
I have a question for Jim about the review it 20 years prospectively. Do you have a different reaction to that since it's kind of understood at the front end?
Yeah, it does. I would support that because I think that's a key for me that, you know, going in. So yeah, I don't have an issue with it if it's at the front end.
I also wanted to call attention to the act sentencing that was added for the advanced supervised release recommendation. That also was in response to some comments we saw in the straw poll about not looking back, but going with everybody being on notice. And we also got that feedback from DPS as well, that of course they have no authority there. It's all about what happens at sentencing. So for that advanced supervised release one, we're also talking about a sentencing decision.
All right, I think we're cutting close on time, so maybe we go to the next set of recommendations. And again, this is continuing on with addressing future sentences. We would be suggesting eliminating the future use of habitual felony status for individuals under the age of 21 at the time of their offense, and for individuals that are convicted of non-violent drug offenses. This is mirroring a program, I believe, that is being used in certain counties. That goes to the 7th and 8th recommendation, where the district attorneys should establish a working group to review and approve every habitual felon charging decision, such as is the process being used in Mecklenburg County. Also suggesting that district attorneys track and regularly strategize to address the racial disparities in their charging decisions. And then bumping back up to that 6th recommendation, we would also be looking to amend the habitual felony statute to limit the look back period to a period of 8 years of the charging offense, right? So habitual felony charges are brought when somebody has multiple felony convictions. Ultimately, this recommendation is suggesting to limit that look back period to felonies that occurred within the last 8 years of the charged offense. And
so Mercedes, to be clear, these are all essentially in the alternative, that if the habitual felony law is not eliminated, these are ways to ameliorate its negative impacts.
so we are, right. Well,
No, we're,
there is no suggestion to eliminate the habitual felony statute, except for individuals under the age of 21 and for individuals convicted of nonviolent drug offenses.
What was number 4 that we just looked at?
That was for violent habitual felons, which is a very, very narrow group of habitual felon
Thank you.
Regular habitual felons are included in that proposed study by the Sentencing Commission in our bullet point number 2. We had a really thoughtful and interesting presentation by District Attorney Spencer Merriweather from Charlotte, and the discussion basically formed around if we have this, anytime there's unlimited discretion, bias can creep in. So how do we help guide, put up some guide rails to help prevent that from happening? And these particular thoughts came out of that. And I'm hoping he said he would share his office's guidelines, so I'm going to follow up with him on that.
And he did, and it's saved on our share drive.
Okay.
And so the other recommendation is with respect to habitual felony status and statute, it would also be suggesting to limit the look back period to a period of 8 years.
I should note that I was a dissenter in that process. It was my view that habitual felon status should be eliminated, that the racial disparities were so clear that to suggest that for the task force to suggest study, review by district attorneys who have not been inclined to have the view that Jim Woodall or Spencer Merriweather might take in their offices is a bridge too far, and that the better route would be to eliminate the status at all. District attorneys have a huge criminal code to pick from, have other options, and the habitual felon with a 60% use of people against people, 60 to 66% use against people of color is not a tool that should be available.
Okay, I think the next set of recommendations, I believe, have to do with prison programming and prison discipline. And I'm not seeing the screen real quick, bear with me. So these were quite intense. And so I asked somebody if they maybe could share the doc, pulling up the doc might be the best way to review these quickly with the time that we have. But these recommendations broke down to about 6 overarching recommendations. The first being transforming the use of restrictive housing. The second is enhancing prison personnel. Third is increasing funding for mental health services and programming. The fourth addresses the due process protections for those that are accused of disciplinary offenses like infractions. We have a series of recommendations related to pregnant individuals in jails and prisons, and then a series of recommendations related to restorative justice and rehabilitation programming. Really quickly, talking about transforming the use of restrictive housing. If we go to the next slide, this looks like establishing a committee within DPS, including stakeholders, including those with lived experience in restrictive housing, to monitor and collect data concerning infractions and the use of restrictive housing controls, and to submit an annual report to the General Assembly. Please note that the full language of these recommendations are going to be in that document. These had to be condensed a little bit. The second recommendation is for these select group of individuals, limiting the use of restrictive housing by implementing hard limits that are modeled after the Mandela rules, specifically ending restrictive housing for people under the age of 21, pregnant individuals, people diagnosed with serious mental illness, disability, or substance use disorder, prohibiting the use of restrictive housing in general for indefinite periods of time, and then also prohibiting the use of restrictive housing for periods of more than 15 consecutive days. Third recommendation relates to reducing the types of infractions that can lead to restrictive housing, things like profane language, unauthorized tobacco use, and then vague terms like general dangerousness, making those terms more clear. And then the fourth has to do with implementing step-down plans or transition programs for individuals that are in restrictive housing, and that would require the use of multidisciplinary teams to come in every 30 days, which theoretically people would not be in restrictive housing for 30 days, but making sure individuals are meeting with a multidisciplinary team every 30 days, and that there's a step down plan specifically for people that are going to be discharged within 90 days so that they don't go from restrictive housing directly into the community. So that was, those were very offered very quickly. We had a series of discussions on these by various presenters. The second set of recommendations under prison discipline are primarily having to do with increasing funding for prison personnel. That straight out away, that is the first recommendation, increase funding and resources. The second is increasing wages for prison personnel to ensure a livable wage and to assist in recruitment. We changed that. We had some language regarding the cost of living, but there were concerns about disparities and the competitive nature of employment. And so we just changed that to ensuring a livable wage. The third was requiring all prison personnel receive crisis intervention training and also implicit bias training. Fourth is providing special training to the individual correctional staff that is on restrictive housing blocks that would require certification in behavioral health. Third group of recommendations having to do with mental health services in prisons ultimately is expanding mental health treatment with a strong emphasis on cognitive behavioral models and the use of therapeutic diversion units, specifically as the alternative use to restrictive housing and as a last resort, only using restrictive housing as a last resort. We added language about cognitive behavioral models based on some feedback that we got from task force members. The second recommendation under increasing programming is increasing the use of incentives for good behavior for opportunities to get credit days towards sentences and things like access to more programming and phone calls home. We heard some very promising presentation from Commissioner Ishii on the different types of incentive programs that they're going to start rolling out in DPS. And our set of recommendations that have to do with due process protections. These ultimately are asking for a review of the process, reviewing the due process protections of individuals that have infractions, and then also tracking decisions by individual officers in order to monitor for bias. We're asking for a review of how A99 and B99 infractions are imposed, and those have to do with conspiracy or attempt in aiding other infractions. Also, a review of how confidential informants are used, and that relates also to kind of the conspiracy and those types of things. These are recommendations brought by task force members. And then last one there is reviewing and modifying the process for security risk groups so that they help people de-affiliate from gangs and make management units more accessible through the DPS facilities. So security risk groups, when individuals are suspected or shown to be affiliated with gangs, they are kind of labeled with in different security risk groups. And this recommendation was rewritten to make sure that it was clear that the recommendation is to modify the process in order to help people de-affiliate from gangs and then increase the programmings that help, they call them management units, increase that programming and make it more accessible throughout DPS facilities and all the DPS facilities as they're limited, And in order for people, again, making it people to have more access to programming, because having this label often limits the access to programming that individuals can have. I think those are it. Okay, nope, yeah. 2 more series under prison discipline. These have to do with our pregnant individuals in jails and prisons. The first being to enact the DPS use of force policy that is currently in effect into state law. There is some comments about making sure that there are exceptions for when the individual is a threat to themselves or others. The way that DPS use of force policy is currently written, it does allow for that exception. And again, the recommendation is to just enact that state law, that policy that's currently in place, into more statutorily. The second recommendation has to do with jails and detention centers. So jails and detention centers are, they have administrative rules that apply to them, and the recommendation has to do with encouraging jails and encouraging DHHS to implement a rule that addresses pregnant individuals, and then also encouraging detention centers and jails to update their operation manuals in order to address restraining or not restraining pregnant individuals. The third recommendation goes to increasing funding for the construction section of the Division of Health Services Regulations. This is the section of DHHS that conducts inspections of county, municipal, and regional jails and detention centers. They monitor for compliance, and they also provide technical assistance to these government entities in order to make sure that they're complying with the jail rules. And the last is examining the offender maternity leave program and looking to expand its availability. That has to do with protecting pregnant individuals. And then the last recommendation last series of recommendations related to prison discipline have to do with restorative justice and rehabilitative program. And it is ultimately to provide restorative justice and rehabilitative program at every unit for every custody level. Also increasing opportunities for incarcerated parents to participate in parenting classes and have meaningful visitations with their children. We heard from an individual that works with children and families through the reentry process, Melissa Radcliffe of Our Children's Place, who suggested things like expanding the match program and developing similar programs, parenting programs for men's facilities. And then the third here is again having to do with the security risk group status, ensuring that those individuals have timely access to programming and requiring DPS to report the effectiveness of that programming. And I believe that's it. It's a lot. We did a lot in our working group.
Yeah, several of these recommendations for review and modification have budgetary impacts. Many of them are programs that DPS has already got pilot or projects in one institution here, one institution there, but the needs are overwhelming. And so whether it's gang affiliation, breaking, or restorative justice and parent support and matching programs, they all require resources that are not currently adequate to do even what DPS has identified as necessary and appropriate. So these provisions do have a common need, and that is some additional resources.
Secretary Hooks, can you speak to these? I mean, we look to your expertise. We know that a lot of it, I mean, your workers, they all need higher pay. We know that, and the programs that Henderson just referred, they cost money, but understanding the money component needs to come along with it. Where are you in reaction to these various proposals?
Very much supportive, conditioned upon money. Prisons itself operates with a structural deficit, mainly due to the lack of funding in our healthcare budget. So, you know, as the phrase goes, robbing Peter to pay Paul, there's this constant shifting. And so to enhance staff, that does require money. We want to professionalize our staff. That has been emphasis of certainly of mine since I came here in 2017, to make sure that not only just pay for pay's sake, but that they are equipped with all of the skills that they need, because unfortunately they have had to be more responsible for mental health treatments, programming, and things like that, that individuals have not received on the outside. And so we often receive people by court order on the back end of the trauma of their life. And so that they need to be, as well trained and as well prepared to meet the needs of the individuals that have been placed in our custody. And so those are all well received. There are nuances about certain things that we can do at various prisons due to space and other with that. But I think that the devil will be in the details in the implementation phase.
Thank you so much, Secretary Hooks, for your support. I just wanted to point out on the restorative justice and rehabilitation programming, I think it's that last slide. Our work group was actually prompted to discussion of those issues by letters from Mr. Christopher Hart and Mr. Johnny King that are available if the task force wants to go review them on the SharePoint. But they are incarcerated individuals who wrote quite compellingly about how helpful the restorative justice programming was to them and to their growth in prison. And that type of programming is just critical. Most of the folks who are incarcerated do go home someday. So we want you all to have the resources you need to work with them. So anyhow, thank you. I felt that was important to bring forward.
Appreciate it.
Any other comments or questions?
Yes, this is Kerwin Pittman. It's just a question that I had regarding the SRG status. So once individuals are on post-release parole supervision with this SRG status label placed upon them, meaning the security risk group, it now becomes a CTG status, which is a security threat group, which enhances their them likely to be stopped by law enforcement. So is it any type of way we could put something in place to kind of give them access to be able to step down and step out of that label if they have denounced their gang affiliation as well, to put something like that in place?
Thank you, Mr. Pittman. A lot of that comes, and there's a variance with the communities, what's available for community resources, because they are on post-release, and we would try to direct them to programming within that area in which they live that would help them to readjust in the community. That also means finding housing. That also means hopefully getting a good job so that they can support themselves and their family and whatever available resources that are out there. The reality of it is, and I appreciate all of our faith-based partners and our community partners, there's just not been enough programming out there, and maybe programming dollars to address all of these needs. And so it takes both funding for the governmental entities and then entities in community to help reintegrate people back in society. Ms. Pollard made an excellent point that the vast majority are coming back to our communities. My earnest goal is to return them to the community better than they are, but not to forget them while they're there, to make sure that they have access to opportunities as well. And people that know me through the years know that I am certainly not soft on crime. And so the best public safety measures is to make sure that people have opportunity to grow and be productive parts of our society.
Before we move to vote, I wanted to make sure that the task force is aware that there is another amendment on the table. The second look act recommendation is being pulled for the end for a number that you already heard, but also Dio Woodall has put an amendment on the table as well regarding the exclusion of first-degree murder and rape from the second look act. So that is another one that we voted on at the end.
Jasmine, how many other of the various proposals have amendments being considered, or is it only second look act at this point?
There are 2 or 3 separate ones in the redressing sentencing recommendations, and then there's an edit to the sentencing commission recommendation as well to add felony murder rule.
Okay, so we'll pull those few.
Yeah, just
My-
real quickly, my amendment was for murder, which would be first and second.
Oh, okay, I'll make that change.
Michael, are we ready to vote on all the other amendments?
I believe so.
Okay, great.
Sure.
If everyone's ready, then we'll go ahead and hit the poll and get your thumbs ready because we got a lot to be voting on. Ellen, good luck managing this process.
Thank you so much. This first one is the set of 4 collateral consequences that are up in this poll. So I'm going to share now. All right, I'm at 17 people having vote. Oh, there's an 18th. So I think we should be set now. If anybody needs a little more time, raise their hand. Okay, great. I'm going to stop the share or the poll. Share the results.
And the results for those who cannot see were broad, widespread consensus for each, with one of them being unanimous, the DMV one. Thank you.
All right. Next up is our first of 2 polls on redress of sentences. I'll share that now. All right, we're at 18 people voted. I'm going to end and share.
And for those who can't see the poll results, all of these passed overwhelmingly, some unanimously.
Excellent. So now here is the second part of the redress sentences recommendations.
Just to be clear, this number 1 is the prospective because we pulled the Second Look Act. I'm seeing Mercedes nod her head yes.
We're right at, oh, there we go. Always when I say something. Okay, I'm going to end the poll and share the results.
And this one, all of them passed. The one that was less unanimous was the violent habitual felony status elimination, was 72% to 28%.
All right, we have 3 polls related to prison discipline. My apologies for these being split out. It's a technological feature, but here is part 1. All right, we're at 18 folks. I'm going to end the polling.
And to report on these proposals, very widespread consensus, unanimous on most.
All right. Second to last. All right.
And these results, similarly, very broad consensus, unanimous for most.
Okay. And this is our last one. All right.
And these all passed unanimously. Wonderful. So that's it for work group 4, Ellen.
Yes, it is.
Well, thank you, work group 4. You all have clearly done a lot of work. Appreciate your diligence in putting so many proposals before us. Thank you to the full task force for your attention and review. We have a few that we will take up at the end of our meeting. At this point, we're going to take, how about 11:32? We'll come back. My computer says 11:27. So we'll come back in 5 minutes. Why don't everybody just keep their screens, stop videos, mute, but come right back in 5 minutes. Thank you. when folks are back, they could turn on their screens. I'll know everybody's here. We can get started again. Okay, I think we've got enough folks back to begin, and we move now on to working group 1, and I'll hand it off to Mayor Colvin and Leslie.
Thank you so much, Attorney General, and thank you to the members of Work Group 1, Representative Gallagher, also Chief Davis, as well as Sheriff Ingram, and certainly Leslie and the team have been a great asset. We have looked, I think we've made a tremendous amount of progress in our work group as we have had thorough discussion and recommendation of topics that were included in the executive order and the Idea Bank, which address recruitment and retention, training, accountability, and culture. And so we had our last meeting on yesterday on 11/12. We discussed recommendations that we would make to the Standards Commission, as well as to the Sheriff's Association. And then we discussed psychological evaluation of officers, and should have recommendations available and ready for the full task force meeting on next week, 11/18. And at this time, we don't have any future meetings planned. And so with that, I will give it over to Ms. Leslie Dismukes to kind of go over the recommendations and present to the task force.
Thank you, Mayor Colvin. We could have the next slide, Ellen. The 3 sets of recommendations that the working group has for the task force today are centered around body-worn cameras, police recordings of all types, and then also asset forfeiture. So if we could move first to the body-worn camera recommendations. And these are not the full recommendations, as Ellen has noted here in the slide. The recommendations are in the library, but generally speaking, the recommendations would be first to amend the police recording statutes to specify that what we deem a critical incident shall be publicly released within 45 days. We have defined what we believe a critical incident to be. I believe that's on a further slide. Similar to other states where there is a critical incident trigger for transparency, these things would be released to the public. Body-worn cameras must be mandatory for all law enforcement agencies in North Carolina. And then the agencies should also deploy dashboard cameras in all vehicles that are utilized either for patrol or in a field capacity, making sure that we have coverage, blanket coverage for anyone who is in a frontline patrol field capacity type role. I'm going to go to the next slide. Some of the feedback surrounding these recommendations requested more specifics about who should wear the body-worn cameras and when. In our recommendation, we did talk about the fact that patrol, and the reason why we said those in a field capacity is because sheriff's offices don't often have what they deem patrol officers. They don't call them patrol, although the sheriff's deputies do in fact patrol. And so we use the words field capacity after debate within the working group. Chief Davis and Sheriff Ingram talked about that and felt like that would best cover who these frontline individuals are who are having contact with the public in a non-investigative capacity. We also then further discussed the investigative capacity and that individuals who are investigating should in fact wear their body-worn cameras when they are doing the investigation, except in certain circumstances. We didn't go so far as to delineate all of those circumstances, but recommended that we seek feedback on what best practices would be surrounding when you might turn off a body-worn camera, for example, during the interview of a rape victim, for example, or a domestic violence victim, a victim of domestic violence. And so the recommendation centers around really studying and surveying what those best practices are to determine. So I think that we will have more specificity probably in the next phase of this recommendation. But for now, the working group wanted to get out there that individuals in a forward-facing patrol or field capacity should in fact wear the body-worn cameras. If we could have the next slide. And if there are
John
any
Lightning, a
questions,
couple
certainly happy to answer questions.
Yep. John Lightning? Hello?
Chief Lenny?
Go ahead.
Thank you. I didn't know if my mic was working. It was my research around body worn cameras, and we've been doing this for quite some time to implement a program locally here. We've learned that several early adopters of body worn cameras across the nation have since traced back those steps and gotten out of implementing this technology for two main reasons. Number one was cost. And not only of the cameras themselves, they're not overly expensive, but the storage and the management of it. And generally, these are unfunded mandates, which means they come out of local taxpayer dollars, and not every community across the state can afford that. Secondly, was related to the increase in staffing needed to comply with records requests, because there still are redactions that are necessary and so on, of confidential information or so on. And so I know at least one larger department, when they implemented body cameras several years ago, had to hire 5 full-time staff members solely for the purpose of handling public records requests. So I wonder if there's any research around that. And then the other issue was around privacy concerns. And that while several communities early on wanted their police to have body worn cameras, after a number of years, they decided they didn't. And they had some pretty significant privacy concerns about being recorded and so on. And of course, that's not universal, it's not across the board, but it was an interesting twist in the implementation of body worn cameras that I wondered if your work group did any research surrounding any of those issues.
Chief, I'll tell you, we didn't have any research on that particular issue. There was lengthy discussion about the cost that this would require agencies and communities to incur in order to stand up a full body worn camera mandate. That said, I think the work group on balance felt that the importance of having that camera footage and being able to use it not only to provide transparency to the public, but also to protect the officers from certain allegations that might be made. So really we would know exactly what happened. On balance, I think the working group decided that we wanted to take the first step and say we believe they should be universal, and then wanted to later on in the implementation support more funding or ways to help agencies that could not find the funding, or local municipalities that couldn't find the funding for body worn cameras. The recommendation recommends that whatever legislation is enacted have at least a 2-year stand-up time, so that we can help figure out how we're going to accomplish this and achieve that goal. So I think that was part of the discussion that the working group had in making sure that occurred. The recommendation also did take into account the fact that there will be people who will probably want to contest the release of certain portions of these recordings, and there may be portions that we do not want to release publicly for privacy reasons and other reasons for victims' families. And so we did also, as part of that recommendation, build into the recommendation that there's an ability for parties to object to the release of certain portions and to go to the court for that. And then also noted that it would require significant redactions, and wanted to make sure that any party who was in the video who was not a culpable party, so any victim or non-involved party, would have 10 days notice before the video was released in order to make any requests of the court. And so we did not flesh out the exact specifics regarding some of the other funding issues like the storage of the data and that type of thing, but wanted to put these general principles out there, hoping that we can build on them and solve some of the larger problems that you've raised.
And I see that's a great conversation that I'm sure your group had. I just want to caution that while those are all good provisions, it comes with an extreme workload on an agency that smaller agencies, which most agencies across North Carolina are under 25 officers, likely will not have the administrative staff to do that. And so the more restrictions that are in place, the more notice and so on, it will become an administrative burden that agencies are going to have to figure out how to comply with.
Did you miss the language, if you had in there, that the footage would not be released if it was found to impede an ongoing investigation? Was that in there?
Yes, sir. That is under the recommendation, that subsection A, the recommendation reads, release may be extended for a specified period of time by court order if clear and convincing evidence exists that release would compromise the integrity of an ongoing criminal investigation.
Right.
And we got that language. It's similar to California's language that we adopted and changed a little bit to fit North Carolina.
Okay, thank you.
Yes, sir.
Leslie, this is Eric Hooks. I know most of the discussion was probably generated around local municipalities, and did you all factor in the idea, and I know you said field staff and maybe as a compromise versus uniformed. I'm trying to get my head kind of clearly wrapped around it and what would move me to support it or not support it, because I have to take into account when we say all officers, that would include the State Bureau of Investigation, that would include ALE, which have some unique missions, and they're not uniformed, and they carry out a variety of investigative functions and Homeland Security functions, as well as other things that I won't go into, that is not conducive to wearing body cameras. And so I know you said that maybe in the next phase that could be addressed, but as I'm just trying to see if I can get there or reserve an objection for non-uniformed agencies.
Yes, sir, Secretary Hooks. The discussion centered around the patrol and or the words field capacity specifically for that purpose, recognizing that there are officers out there in undercover capacities or detectives who are operating in an environment that isn't conducive to a body-worn camera, like perhaps an ALE agent, and in what their charge is and what they typically do. And so the choice of the word field capacity was, I think, at the recommendation of Chief Davis, to make sure that we could delineate or draw that line between those types of individuals. So it was not meant to encompass the folks that you note that may be working in a different capacity where it's important for them to maintain anonymity in order to do their job. We perhaps could be more clear about what field capacity means. If that would make you more comfortable, we could do that. But that is what the discussion was, and certainly that was the intent of the words field capacity, were forward facing. The reason we didn't just leave it at patrol is because of the sheriff's deputies, who are not technically patrol officers, but may be out in the field in different ways.
Well, if I could defer to the many bright minds that are on here, and the you and the rest of the staff attorneys, to craft some language that would enable me to move closer to being supportive of it. I just get very concerned when we use all in those type absolute languages.
Yes, sir.
Was there any discussion about the federal task forces or working alongside federal agents, and the prohibition on the federal side for body-worn cameras? And that's been a problem in not only North Carolina, but other states as well.
Yes, sir. There was an extensive discussion about that. Chief Davis actually, and I don't think that she's on the call, and if I'm missing you, Chief, please let me know. But Chief Davis raised the issue that actually just the Thursday before our meeting, there had been extensive discussion at the federal level about that very issue, because they were losing their task force officers because agencies were not allowing them to go be task force officers if they had to wear a body worn. And apparently the federal government has now said that those task force officers can comply with the mandates of their departments as it relates to wearing body worn cameras. And so hopefully that will not be an issue any longer, generally, and also with this recommendation.
Okay, thank you.
If there's nothing else, I think we could move to the next slide. And Secretary Hooks, I'll work on some of that language. Maybe we'll put that at the end for an amendment. And I will work on some language for field capacity and put that in the chat.
Well, Leslie, let me just say, I agree with your description of the functionality test. And as with sheriff's deputies, there are other agencies like the ABC officers, where I think you would not want to make a rule that applies to all ABC officers and all of their functions, because a good number of those officers are conducting themselves in senses that are not undercover, but maybe plain clothes, where having the body camera would be absolutely essential. to assuring the community of in this respect.
Yes, sir. Okay, Ellen, if we could have the next slide, if there's nothing else. The next recommendation centers still talking about police recordings, but from the other angle. Our last set of recommendations that we presented last week dealt with the civilian oversight boards and the release of personnel records to those oversight boards. This would track that same concept, but within the police recordings statute. So it would allow release of police recordings to the civilian oversight boards. And again, those we specified, similar to Justice Earle's amendment from last week, those who are sanctioned by their local communities would allow them to receive the access to critical incidents. And then this is the definition that we came up with for critical incident based upon the research that had been done in this area. So an incident involving the discharge of a weapon by a justice officer, or an incident in which the use of force by a justice officer results in death or serious injury. And the discussion centered around how do we narrow the access of the critical incident files, because as you know, in law enforcement, if we have all of the body worn recordings for every officer who are uploading them every day, that's a very large amount of data. And there was significant conversation about turning all of that over, and we settled on turning over critical incidents to the civilian oversight boards and city, town, county councils for that. Next slide, please. I think the one concern was that the release of those recordings should be done by the prosecutor or a court when there are potential criminal charges involved. And that was part of our discussion and something that we spent a lot of time on. And that was the reason for the extension of release of the critical incidents. The 45-day extension can be granted by a court if there's clear and convincing evidence that release would compromise the integrity of an ongoing investigation. And so we settled on that language to specifically address that issue. And I think that was the majority of the feedback for that issue. If anybody has any questions or
A
thoughts.
point on the definition of a critical incident. While I understand the intent, and I appreciate you defining that, because that was one of my questions in the straw poll. And I'm sure the intent is only when it's an actual incident. However, the way it's written would say anytime an officer fires a weapon. We had the same problem with accreditation standards many years ago because an officer fires a weapon at the training range regularly, and that's not what this standard is related to. So if we could amend that to reflect an incident where it's in the performance of duty at or in the direction of another person, that kind of thing. Just to make it clear that we're really not talking about any time an officer fires a weapon.
Yes, sir. I can add that.
And there are also times where officers will humanely dispatch an animal with a weapon, and I know that's not what you're talking about either, but that's just another example of why I think we need to define it a little more succinctly.
I can absolutely add that. And Helen, if we'll pull that one too, I'll work on some language in the chat before the vote at the end.
Great.
Okay, and I think then the next thing was asset forfeiture.
One sec, sorry.
Sure. We had a lengthy discussion in the working group about asset forfeiture. We had a presentation 1 week and discussion, and then followed that up the next week with a lengthy discussion about asset forfeiture and essentially the incentives that the federal asset forfeiture program creates sometimes. Where we ended up is that, of course, if a criminal conviction results, then there's not an issue with the seizure because it would be understood that those proceeds were in fact related to a criminal act. But the problem comes in when there's not a criminal conviction and there was still a seizure of money. And the group spent a lot of time talking about in large amounts of money, there are many different reasons why a criminal conviction may not result. But when there are large amounts of money on the table, it is more likely and more indicative, along with other pieces of evidence, of a large drug trafficking organization or scheme. And so the seizure if we did not seize that money, then it would go right back into the organization, the drug trafficking organization, and that would be a perpetual cycle. However, the group felt that in situations where at least $5,000 or less, that there are any number of reasons that someone could have had that amount of cash on them. They could have sold a car or a house or just cashed out a bank account or anything like that. So we wanted to make sure that those individuals were not being penalized and would be able to receive their money back. And it was less of a likelihood that they would be using that money to perpetuate a large-scale drug trafficking organization. So we settled on, if there is no criminal conviction and the seizure is less than $5,000, then we should prevent the seizure of those assets or ban the federal adoptions in those circumstances. And I believe the question was, I think the feedback was, why the $5,000? And we talked a lot about what the prices are for different types of narcotics. For example, a half a kilo of cocaine could go for around $14,000. And so, you know, if you're looking at money, that certainly could be indicative of a large scale drug trafficking organization. But everyone in the group felt fairly comfortable with the fact that $5,000 was a number at which an ordinary citizen could have that much cash on them for a variety of different reasons. And I think with that, any other questions?
Well, in addition to that, that portion that Leslie mentioned, it also was highlighted that if someone's assets or property is stolen for $5,000, it will cost them at least that much or more to get legal representation to go through the process of getting it back. And we didn't think that was fair. You know, now some of the larger amounts and the indication that it may be tied to something a little bit more organized or what have you. You know, the committee or the work group felt that you know, that was worth you know, pursuing other methods that it was a little bit more complex to receive those funds back in the larger amounts. And we had a pretty detailed discussion about it, not to try to minimize the importance of $5,000. You know, it's all relative to what it means to different people. But as Leslie mentioned, you know, we didn't find it was fair that you would have to pay $5,000 to legal counsel to receive $5,000 or small amounts, that was no longer practical. So we'll leave that open to discussion, but that was kind of some of the context behind the thought process.
This is Kerwin Pittman. And so here's the issue I'm having. The amount specifically being $5,000. So what if somebody has $5,500 and it's gonna cost them the same amount for a lawyer to try to fight for this? So it's the number itself kind of being extremely low, because $6,000 or $7,000 is not indicative to a massive drug trade organization deal, and individuals in that capacity could possibly be carrying about this amount of legal money on them that could get seized, and they may not have the opportunity to get it back, or still can't afford for a lawyer to pay a lawyer to get $6,000 back or $7,000 back. So it just, 5,000 seems a little too low, in my opinion.
Well, this is Secretary Hooks. I'll weigh in concerning that. And you get up to $5,000, $6,000, $7,000, you certainly can buy a quarter kilo of cocaine and a number of other Schedule 1 and Schedule 2 narcotics that could play a large of a part of a larger criminal enterprise. And so, you know, in one sense, whatever the number is, there's always going to be somebody that is $1 over that. Or $50 over that. And so even though I'm not certain that I even support the $5,000, that sounds more reasonable to me than a $7,000, $7,500. You know, I've been in my career a long time, and I'm not walking around with $5,000, most of the time not even $50. But that's just the perspective that I have from my background and networking both on the state and federal level.
Well, I don't know what Secretary Hooks just said. If he's not walking around with $50, I don't want to go to dinner with him. But I think my problem with this, if there's no criminal conviction, why are we giving this tremendous incentive to seize assets? My problem with it is that people travel with family, and family have cash for different reasons. Family has automobiles and other things of value. If there's no conviction, why are we imposing this penalty on the individual, his family, others who might have who have had innocent reasons for having this property, these assets, and without a showing of guilt? It seems like it still incentivizes agencies to seize property and to make the seizure the end of the purpose for the interaction. If you're driving around with a shiny car, that makes it an attractive unit to stop. And my problem is less the fact that, although Mr. Pittman's point is strong, and I agree, that same issue arises whether it's $10,000 or $20,000 vehicle.
And I think to address that issue, one of the conversation centered around a particular example, I think that the chief may have given, but in a situation where a courier is pulled over and the courier has $14,000 in the car for a drug trafficking organization, that individual might not end up with a conviction because they might end up testifying, or officers might understand that that individual is not the high level cartel member or drug gang member that needs to be prosecuted. But if they don't seize the money, then the money gets put right back into the large organization. And so that was the example given at the working group, talking about that, and also that there are lots of different reasons other than simply those that align with that example for that there may not be a conviction. And so I think that was where the working group came down in terms of thinking about that particular issue.
So can a provision be put in place to kind of address this issue? Meaning if there is, and just verbiage for lack of better terms, strong suspicion that this individual may have been involved in a drug enterprise or something in regards to that nature, because the collateral consequences for individuals who may have this sum of money but yet have not committed a crime but yet still have to fight back for what's theirs rightfully so without a crime being committed. It just seems unprecedented to me.
And that process is already in place, at least at the federal level, because it goes through a marshal service, and there is a civil process for the money to be formally seized before it's returned back to any agencies or anything along those lines. I don't know the ins and outs of it, but it's not just a process without any oversight. And generally it goes through a federal court, is my understanding.
And that's one of the most impossible processes to navigate. The U.S. Attorney's Office and the Treasury Department have enormous resources to prosecute those seizures. The individual has almost zero resources to navigate a very complex system. And it strikes me that the controversy over the federal asset seizure law is so ripe with inequities that for us to sort of attach ourselves to that policy just seems wrong-headed. And in the absence of a conviction, the presumption should not be that these civil assets go to the government. And this is one area where I think I think the sort of political, and not to introduce politics in it, but we have extreme political views, super conservative, reactionary folks, and super radical, progressive folks agreeing that there's an incentive here for governmental overreach. And we should be guarding against sort of cementing that overreach in the recommendations that we put forward.
And I think that what you just described was exactly the kind of detailed debate, so to speak, that we had, that they talked about how cumbersome that process is to get the money back from the U.S. attorney for an individual, and he would have to hire a legal counsel. And if his legal expenses exceeded the money or took a significant amount of his property, then it was not worth it, and they walked away. The other thing is that we had a real problem with people losing property that were not convicted of anything wrong. And the state's statute, if I remember it correct, when we compared it, said that it was if it was convicted, it was forfeited if they were convicted. But what we understood the law enforcement to say is that if these are federal cases, it comes those federal rules which remit it back, you know, if it's not filed within a certain time or the process is not followed, to the department. And so our question on the work group level was, couldn't the state then, once the property is remitted back to the different agency, make a decision to add a caveat to it that says if this person wasn't convicted, that you give it back? I mean, that was what we didn't understand, because they said if we changed any of the rules on the front end, that it would impede the federal task force or the ability to work with the agency. And that was, you know, I asked our chief, and she said, well, you know, we got a lot of joint task forces, and if the case is taken federal, then these are the rules that come along with it. But I mean, after the federal government writes the check back to City of Fayetteville Police Department, it should be a way that we can determine then what happens to it if the person is not convicted. So that was the kind of discussion we wanted to hopefully have today with the overall group.
Mayor and Leslie, if I could jump in real quick. The chief in Fayetteville is absolutely right. There are prescription guidelines that come from the federal adoption authorities and the programming that allows for this, and that if the money went to a law enforcement agency and then subsequently was taken from that puts the agency at risk for not being able to participate in that program. I don't have the specific recollection date, but I would say that in the 90s and historically before that, it was extremely, and I'll use the term easy, for law enforcement to seize money and have it forfeited over. But maybe at least, I'm thinking maybe 10 years ago, the federal guidelines changed from both US DOJ and Treasury to require what Mr. Pittman referred to, basically reasonable suspicion, probable cause to type of a threshold, reasonable suspicion to take money. So it's just not an unfettered access anymore to just take guidelines. So they tightened up the guidelines after some challenges on the federal level as well. And that's the program that we have today, not the one in the 90s where the so-called declared war on drugs and officers were wantonly seizing money with no nexus to any drug or other major criminal activity, just for some context.
And to add to that, Secretary Hooks, I think the other piece of that is that now, and this may have happened back 5 years ago or so, maybe 6, where it used to be that money could be seized regardless of the federal agent's involvement in the case. And now the federal asset forfeiture program can only be utilized if there is in fact federal involvement in the investigation. So it narrows that scope and also narrows that incentive for errant stopping of cars just to try to gain the money that would come as a part of the dividends from that. So it actually requires an investigation that is a federal investigation, and federal agents are involved. And to speak to Mayor Colvin's point, the difference at the state level is that it is a tax on narcotics. And so at the state level, the asset forfeiture is operated through revenue, and it's a tax on the drugs. So when you seize drugs, that amount, if it rises to a certain level of a certain amount of narcotics, can be taxed by the Department of Revenue in North Carolina. And so the check and balance there is that you actually have this large amount of narcotics that has been seized before any tax is levied, before any of the money is seized. So there is that nexus that's there at the state level, which operates differently than the federal asset forfeiture. So this recommendation, to be clear, is just about the federal asset forfeiture operation.
So before we move on to voting, wanted to check again to see if there are any other comments about this particular recommendation or any of the other recommendations from work group 1.
I'll just jump in real quick because I don't know that I have a complete understanding of the asset forfeiture as it related to the amount of money we were discussing. But just listening, and these are just my thoughts, I feel like absent a charge and a conviction, the tie needs to go back to the person who possessed the money. And if we can't in good faith and conscience prove that that money was in fact related to drug usage, then why would we be seizing that money to start with? And why would us as a task force attempt to attach ourselves to something of that nature? If there's this much concern, I think we need to start back over at on the drawing board on this one, because to me it just seems like, you know, we live in a country where we're allowed to go and come as we please for the most part, and how much money I carry is kind of my business. And if you're going to say, you know, it's part of a drug ring, then you need to be able to prove that. And if you don't convict me of that, I want my money back. It's kind of how I see it at the bare bones level. And for me to support it, I would have to find that there was a way to prove that this money was in fact part of some drug usage.
And Sergeant Garten, we did talk about that. Because that was a concern that was raised. And the issue with the federal asset forfeiture is that the seizure happens at the front end, and that money is seized at the very beginning of an investigation. And so the options that we have, we cannot change the federal asset forfeiture law and how it currently operates, because the state cannot modify the federal law. But we can enact in our state as a form of an anti-circumvention statute, which is what our proposal is an anti-circumvention statute, would basically say that the state limits your participation in this federal program only for amounts greater than $5,000, essentially, when there's no criminal conviction. Because once the money is seized federally, in order for us to then tie it to a conviction, what would unfortunately happen is that if the money had to go back to the individual, we cannot force the federal partner to give us their share back. And so then the agency would be on the hook for that amount of money to go back to the individual, which would put a tax essentially on the law enforcement agency also. And that was the discussion, and that was the point I think that Chief Davis raised in the difficulty. And of course, it's just the difficulty in the interaction between the state and the federal laws there. So we did discuss that, and that was kind of what Chief Davis had to say about it.
Okay, Attorney General Stein, I think we're going to move to voting.
All right, Ellen.
Great. We have pulled 2 of these recommendations to be worked on, but that means we have a poll of 3.
And Chief Letney, just so you know, number 1, the critical incident definition is actually not in that recommendation. It's in the other that we have pulled.
Great, thank you.
And these results have come back with broad consensus and support. Ellen, how many more rounds of voting do we have?
Oh, no, that's it for this particular group. So I think we're moving on to working group 3 now, and I will share my screen.
All right, great. Thank you, working group 1. Appreciate your hard work.
Okay, I guess I should go ahead on working group 3. We just have a couple of recommendations. And before we get to them, this stems back from a October 21st working group meeting that we had. And we were talking about restorative justice, victims' rights, and also the Victim Compensation Fund. We heard from Danielle Sarad, who's with Common Justice Organization, who's done extensive work on restorative justice throughout the country, has written books on it. She's the executive director of Common Justice, and really took a deep dive in thinking of what do we do when we convict people of crimes. And is the goal accountability of the person that does it, or is it punishment? And we really got into what does accountability mean, especially in light of the victim. Do we want a person to show that they have genuine remorse, that they've talked about what they have done, that they're in a process of repairing, making a victim whole? Or do we want just passive punishment and incarceration and no accountability? So looking at those both, and they do intertwine somewhat, that restorative justice programs can be implemented at any stage in the criminal process. It can be before a charge is filed. It could be after a charge is filed, before a sentencing. It could happen at the time someone is incarcerated and in prison to work on restorative justice. So it's really that our response to violence should be victim-centered. And that's what our criminal justice system should be about. It was a very compelling presentation. I think it made us all think a lot about restorative justice. We even do restorative justice in our juvenile system to help kids understand the impact of what it means to harm someone else. So in a moment, we'll hear Natalia and our recommendation on restorative justice. And then another presentation, Jasmine also McGee gave us great information about North Carolina's Victim Compensation Fund and issues around that, which automatically disqualified certain victims from applying or receiving any compensation from our compensation fund, that we think we should make it, take away some of these restrictions, make it easier for victims of crime or perhaps law enforcement activities to be able to apply for victim compensation. So I would hand it over to Natalia. And once again, I really thank members of our committee, Commissioner Ronnie Smith, District Attorney Jim Woodall, Senator Mustafa Muhammad, and Tara Callahan. Everyone's been very involved, and really thank you.
Hi, everyone. I'm going to run through our 5 recommendations on these 2 topics, and I'll explain where some of the changes were made. So one, as Representative Maury has said, the first is an endorsement of the concept and the need for funding for restorative justice programs in local communities, and an acknowledgement that these programs can be made available at various points in the criminal justice system, not exclusively after incarceration. Number 2 is during the implementation phase of this task force to form a victim advisory group to help give us advice on the implementation of restorative justice, as well as other programs that relate to victims of crime. Number 3 on the next slide has to do with our victim compensation fund. And there's national data to show that particularly Black victims of crime are underrepresented in victim compensation funds. And so we want to address that. And the first subpart of that recommendation is exploring additional ways to validate claims. So we did respond to some of the feedback we got on the survey, looking more broadly, not just saying eliminating the use of police funds, or police reports, but acknowledging that can be one way to validate crime, but may not be the only other way. And so we need to do more exploration of other ways that crime can be validated. And as Representative Maury suggested, eliminating barriers for claims. So we have kind of a complex set of rules around past criminal behavior of a victim, criminal behavior that may have occurred at or near the time of victimization. And so this recommendation is about a re-examination of those rules to make sure that our funds are made available to victims in an equitable manner. And then the second subpart of that is just making clear that victims of improper use of police force can also be eligible to apply for this compensation. Number 4, we know that people who commit especially violent crimes are often, have often been victims themselves. And so number 4 is that when people are incarcerated, whether in jail or in prison, they should be screened for victimization and, to the extent possible, provided services to help them heal from previous harm. And then number 5, building off of our other recommendations around racial equity training, we want to extend that also to members and employees of the Victim Compensation Fund, that they should receive mandatory racial equity training as well as victim services training. So with that, we would welcome any questions that you have, and then we will vote.
Ms. Gentle, any question about your definition of improper use of force? Is that related to if an officer is found to have used excessive force violating a statute and is then charged by the district attorney, or is that also inclusive of an administrative violation that does not rise to criminal activity?
Chief, I think it depends on the Victim Compensation Board, and they review it. But someone who is a, quote, victim of law enforcement activity that can show their case, whether or not criminal charges were filed against the officer, it would not eliminate either scenario. If charges were filed, it might substantiate more than being a victim. If they were not filed, they would not be prohibited from presenting their claim.
I would request some guidelines around that because people make claims all the time that are not founded. And while there has to be some redress, certainly when they are, and when there is a problem and there is excessive use of force, just saying it's improper is subject to interpretation and is not, it's not due process for officers as well, and we need to keep that in mind.
Right. I'm sure if a claim is unfounded, they would not receive relief. So they would go through a thorough process and establish clear, convincing facts that they would be entitled to some type of relief from this fund.
Other comments, other questions?
These received a lot of support, so I think we can probably just go ahead and vote.
And so, Attorney General?
All right, Ellen, if you can put the poll up for these 5 questions, please.
Yeah.
How many votes do we have done, Ellen?
We have 17. If anybody is still working, I know we had someone vote the last time on an 18th person. We may have lost someone though.
Okay.
I think we're all set.
Okay.
Yeah.
And these results were all unanimous, these recommendations. So that's great. Thank you, Representative Morey and Working Group 3. And Ellen and team, how many amendments do we have to consider at this stage?
We have a set of amendments to Working Group 4's recommendations. There would be 4 to vote on, and then the original. So I can pull up that slide and Jasmine can walk you through it.
Okay, please do.
Go.
Thanks, Ellen. So we'll do one at a time as necessary. The first one is related to Angelica's recommendation related to victims. Folks will take a minute to read that one. We'll vote on it separately.
My question on that is
here. I don't see the language.
It's the green in the green font on number 1. Do you see it, Henderson?
No, but that's okay. Please just go ahead.
I can read it. Before a Second Look Act is enacted, policymakers should establish a formal method to listen to the needs of harmed individuals, families, and communities in response to violent crimes to effectuate the goals of public safety, harm reduction, and restorative justice, and include those needs in the statutory process.
Okay.
yeah, and they include those in the statutory process was what I was about to ask, but you guys got ahead of us, so that's good.
Yeah.
Okay, why don't you walk us? Well, let's first ask, does anyone have any questions about that amendment? And then Jasmine will go on to amendments 2 through 4. All right, Jasmine, why don't you proceed?
So the next one is adds to the Second Look Act an exclusion for murder and rape. And then and our thought is that we would vote on that one and then vote on Kerwin's amendment to exclude first-degree murder and rape. So first, DA Woodall's. And I see there was some further discussion going on about this in the chat, so we may want to take a moment to, if Kerwin or DA Woodall want to talk through their thinking on that one for the benefit of the task force. But then just for everybody to know, then the final one for this working group was to add felony murder as first-degree murder to some of the things that the Sentencing Commission would study.
I would say that the amendments to the Second Look Act essentially gut the Second Look Act. I mean, the purpose for the Second Look Act is to give an opportunity to redress sentences that 20 years later seem inappropriate. And so the whole thinking behind the American Legal Institute is after 20 years, circumstances may have changed. And it is appropriate for the court to look at those circumstances, hear from the stakeholders, and make the decision. You know, the notion that because a sentence was imposed, a contract or a bond was created with a particular stakeholder is in opposition to any notion of redressing the racial disparities that have occurred in sentencings as a result of prosecutions that have happened. And I think we're being tethered to a rule that does not make possible redressing inappropriate sentences, sentences that are now considered and understood to be inappropriate.
And this is Kerwin Pittman weighing in. And with that being said, Mr. Henderson is absolutely correct. So if possible, can we select from the revision that Mr. Woodall proposed and the original Second Look Act in its entirety as it was put before us in the beginning?
So how it works? Sorry, Kerwin, I didn't mean to interrupt you.
And just exclude my version of it, period, just excluding first degree murder, because with him saying that he's absolutely correct. It totally guts the whole second act recommendation.
I just wanted to push back at that a little bit because I don't think it guts the recommendation because there are so many inappropriate sentences outside this realm of murder and sex offenses. So I don't want to lose sight of how many people we're trying to get some review for here.
Mary, what's an example of a 20+ year sentence that's not murder or rape?
Oh, golly, a string of armed robberies that you do when you're 19 years old and you get boxcarred, some trafficking and drug sentences, armed robberies, some habitual felons I've seen. Oftentimes these crimes are driven by addiction. I mean, I don't know. There's plenty of them.
Thank you for that information.
And just from a process point, what will happen is that we'll vote on each one of these amendments. If the amendment passes, then that becomes the recommendation. If it doesn't pass, you will have an opportunity to vote on the original language as well. So the original language is not, it still exists.
And so I wasn't certain if, Kerr, when you were pulling number 3 or you were keeping number 3, I didn't understand exactly what you were just putting forward.
So what I was just putting forward was to pull number 3, essentially. And so listen to Mr. Henderson. Yeah, I would like to pull number 3 from the record, and in good conscience, I'm going to vote on the original language. But you know, to each his own. Everybody has their own opinion. So we could just pull number 3 from the record.
All right, and that was your amendment that you'd offered. I just want to see if everyone if everyone else is okay. Does anyone else put forward that amendment before we pull it? Otherwise, we'll pull it.
I would just say the problem with categorical exceptions is that one of the most striking example in my mind is a rape conviction for a Vietnam veteran with a Purple Heart, an amazing 25-year career afterwards, who was sentenced on a single count of rape at 58 years old and will die in prison because of the sentences that was enhanced with no prior conviction. Efforts at executive clemency failed. And you know, everyone looking at the case thinks this is a miscarriage. The notion that the charge keeps the court from reviewing it does not make sense. Not when we know that there are, you know, upwards of 4,000 people serving life sentences. The capacity to review those sentences should not be limited simply by the category of crime. That's why we've got a court. That's why we have a hearing that the stakeholders would participate in.
This is Secretary Hooks. If I could weigh in, I do take note of what Ms. Pollard said, that there are other crimes that are certainly listed, but I do hear the other task force members, and and I'm always concerned about never just staying within a box, and perhaps we should be aspirational, but some of these things in reality require a statutory change. And so to advance something that may ultimately fail because you may want to be aspirational may preclude us from really marching some positive steps in a direction. I don't think that, at least in the larger task group, and I would gather you all discussed it in the working groups, that the ability to access the courts through MARs is still there for those murder cases and the like. And if we're asking for triggering second chance automatic reviews, then some aspects of crime may fit that may carry the day. This does not eliminate executive clemency. That's, of course, that's in the discretion and authority of the governor. It does not preclude people from accessing the courts through individual MARs when those sentences, there's a rationale for that. I'm speaking as, of course, as a non-lawyer, but I just want to put that out, and maybe some of the esteemed attorneys on here can either correct my thinking or affirm where I'm at.
And I have a question, if I may. I'm not overly familiar with this act or how it's applied. And while I understand that someone may have exemplary past or exemplary behavior or whatnot while incarcerated, if they're convicted of a rape or a murder, they're still convicted, and there's a victim and victims' families. So does this act include their input and their involvement in the process?
That was just that's the first amendment that will be considered.
Right.
We're about to vote on that very issue, Chief.
Okay. Anyone else on any of these now 3 amendments? We'll pull. Ellen, are you able to pull Amendment 3 from consideration?
Yes, we're actually going to do separate polls for all of them.
That's great.
So we're just super clear.
Mr. Attorney General, if I can speak for a moment.
Surely, Senator.
Just real quick for everybody that's on the task force, just reviewing what the second chance, what the second look act's doing. Just want to remind folks, it doesn't necessarily mean that these individuals' petitions will be granted. I mean, this is an opportunity for a hearing to review a successful completion of relevant rehabilitation programming, the pursuit of educational goals, successfully completing those, maintaining and steady employment and programming that they've done while they've been incarcerated, and looking at their disciplinary record. Because the reality is people do change, and that's why this is called the second look act. I mean, when you've been incarcerated for over 20 something odd years, you've got a lot of time to think, and you are likely a different individual. And just because you gave somebody an opportunity to be heard doesn't necessarily mean that it'll be granted, but at least it's an opportunity to be heard, and it may or may not be granted. So I just want to make sure folks understand that when they're voting on these amendments, and I support what Henderson's talking about here with his efforts.
Thank you. Anyone else? All right, if you can bring forward the amendments.
Great. So this is number 1 on that previous slide. There's 16 votes tallied right now, so I'm waiting on about 2 more people, I believe, can raise their hand if they have not yet voted. Okay, I'm going to close the polling now.
And that one passed unanimously. That was the one for harmed individual input.
Okay, the next poll will be on the amendment to exclude murder and rape from the Second Look Act, and then we will vote on the original. All right, we're at 16 votes. Is anybody else still looking to vote here? Okay, I'm going to end the polling.
And this amendment passed 63-38.
All right. And that means we will move to the amendment to the study. All right. That was our final poll for the working group 4 amendments.
And that one passed unanimously for those watching on the internet.
Great. And then I think Leslie will now have 2 amendments from her working group that I can share.
And then we'll have to bring back the original proposal.
So we pulled the 2. We pulled the 2 that related to these. So we'll show the changed language, even though the poll will not necessarily include this particular language.
Okay.
So to the first question as to whether or not the recommendation that you'll see on the poll is recommend that body-worn cameras be mandatory for all law enforcement agencies in North Carolina. This is the meat of what the recommendation read in the recommendation bank. And these are the, in green, the amendments based upon the feedback from Secretary Hooks and from Mr. Hill. And so making it clear that we took out field capacity and said, or who are performing patrol functions, which I think serves the same purpose, and then clarify that it doesn't apply to plainclothes or undercover when use of body-worn cameras can be determined by their agency based upon what the job duties are of that position. And I don't know, Secretary Hooks, if that accomplishes what you were thinking that we needed to clarify there, or if there is a need for further clarification.
It provides a better framework for me to address.
And then Leslie, here's the second one.
And in this recommendation, you'll see just the top part on the voting poll to recommend including the civilian oversight boards and the police reportings of critical incidents. We changed the definition of critical incident pursuant to Chief Letney's feedback to make it clear that it's an officer who is in the performance of their duty or when interacting with the public, to exclude the possibility of that being required when they're on the range or something like that. Chief Letney, does that get at what you were thinking needed to be changed?
Yes, thank you. Sorry, I'm having internet problems. It does. In the performance of duty may include discharging an animal. I think the intent is clear, and I think that what we're looking for is not those things. So I think this is helpful enough that I can support it.
Would you prefer to just delete "or" in the performance of duty when interacting with the public?
That may make it clear. Yes, thank you for that suggestion.
Can you make that change in real time, Leslie?
I think Ellen can, because it wouldn't change the poll. So I think that we can definitely change that word in the document.
Okay. Does everyone understand what that did? Okay. Those were our two amendments.
Yes, and I have a poll that includes both of them that I can pull up now.
Now, for clarity, this amendment with the body worn camera, it doesn't have the wording, but we're to accept that the amendment is a part of that, right?
That's correct. That's shorthand for the language we just reviewed that you had suggested earlier.
Yeah, I'll pull it up here if that's helpful.
Yeah. I think both of these, well, I won't opine other than to say these are good amendments.
I think I'm waiting on one more person to vote. All right, we're at 15 people, 16, oh, there we go. Sounds great, thank you.
And these passed overwhelmingly, but not quite unanimously. All right, I think that's it for the votes. Am I right?
Yes.
Team? Okay. Well, my goodness, we have accomplished a tremendous amount today and last Friday, and we are now set for next Wednesday. Be on the lookout for your computer screens for proposals coming your way that will be discussed and voted on next Wednesday. But I'm tremendously appreciative for the incredible work that each working group has put in that has been demonstrated by the detail and substance of the proposals today, and for the full task force for its excellent deliberation about these really complicated but important issues. So does anyone have any words for the good of the group?
Thank you, everybody. It's a lot of work today.
It really was. And I want y'all to let Justice Earls know I'm getting us out 13 minutes early. So let her know that I did that.
Excellent work.
Thank you, everybody. Have a great